members of our executive board have done a great job putting together fantastic panels. This is the last one for the year. We're going to have a summer reorganization meeting, and then I'm sure you'll all be getting emails letting you know about programming starting in probably September or October. I want to thank Paul Montalbano, our longtime treasurer, for doing a fantastic job again this year. Lucille Alfano, and Vice President, Kurt Rabovich stepping in as secretary this year has done a fantastic job as well. And to everyone else on the executive board, we're also deeply indebted. And that's why we've remained, I think, a successful chapter. I'd also like to introduce Ken Eggers, who, along with Pat Westerkamp, had the job of assembling tonight's panel. When we had our discussion last summer, I think we knew what a big deal diversity was this year, but it hasn't slowed down in the last however many months since we met in terms of it being, a very topical issue. And when we get lists of panels of arbitrators so frequently, you recognize the names. Sometimes you don't, but a lot of times it is, to be stereotypical about it, it tends to be older white men. And, it's not necessarily reflective of the workforces that we are having our arbitrations for. One person in Ken Egger, who has been an advocate for alternative dispute resolution for over 35 years. He really has an investment in terms of continuing to see the process be effective and trusted. I think part of that he recognizes is diversity and inclusion, which is why he's really worked so hard with Pat Westerkamp to put together a terrific panel. Ken was the winner of the prestigious Peggy Browning Fund Award a couple of years back. He's been a tremendous asset to us since he's been back on the board, as has Pat Westerkamp, who stepped off and came back. So I'd like to thank both of them and turn the program over to Ken.
Oh, thank you, Jonathan. Appreciate everyone. I'd like to take this opportunity to welcome everyone. I know it's probably been a long day and we're starting a program at 7 o'clock, but as a member of the New Jersey LERA board, we've been throwing out different times, and we're going to look at data and find out what times work best. But obviously, we cultivate the program around our advocates, and we appreciate the advocates being available for today's important program. As Jonathan said, I'm very involved in diversity with the American Arbitration Association. We've been really a proponent, like many other organizations, and it's very important that we continue this discussion. And not only do we discuss it, but actually put actions in place to make sure that we accomplish this very important goal and initiative. We had a program a few months back. Lisa Charles participated, and a colleague of ours, Theo Chang. And I think diversity, inclusion can basically be summed up as follows. Theo Chang indicated that diversity is being invited to the party. Inclusion is being asked to dance. So I think that does sum up what we're looking to do and accomplish. Not only the American Arbitration Association, but all the corporations who are involved in moving diversity. It's a very important initiative, and it's something that we should all focus on. With that said, I don't think you want to hear me talk too much longer, but I do want to thank this wonderful panel, faculty and professionals, which will be led today by Alan Symonette, who will be our moderator. I'm going to ask Alan to do the introductions. He's going to introduce himself, and our wonderful panelists, Alashia Chan, Haydee Rosario, and Gwynne Wilcox. And before I turn it over to Alan, this panel has worked tirelessly. They've met numerous times, put together a wonderful program for this evening. So I appreciate their efforts, and I think you will as well. With that said, Alan, I'm going to turn it over to you. Introduce yourself, the panel, and get us started. Thank you.
And thank you very much, Ken, and good evening, everyone. And my name is Alan Symonette. I'm coming to you from Lansdowne, Pennsylvania, just outside of Philadelphia, just across the bridge. I've attended my share of New Jersey LERA meetings, and I've always enjoyed myself in person and having dinner with you. I am an arbitrator, and I was just for another presentation noted that I've been arbitrating for 33 years, which, when you count, is half of my life. I have had the pleasure of doing this work. It is a great and important job. You get to work with different people, different corporate people, and you help to improve the community that I like to call the world of work. Now, tonight we are going to have a discussion about creating paths to a more diverse and inclusive world of alternative dispute resolution. The question of the lack of diversity in the ranks of neutrals has been a prominent subject of discussion in the ADR community for quite some time. Now, while many practitioners have recognized this issue for years, the issue, if you remember, gained media prominence as a result of a commercial dispute involving the celebrity you all know as Jay-Z in a commercial 2018 commercial dispute involving trademark infringement. And in that particular case, to make the long story short, a panel was requested, and out of that panel that was provided, there were only 3 arbitrators of color, 2 male and 1 female, that were provided. And 2 of those arbitrators were not eligible because they were conflicted. Jay-Z's attorneys initiated a lawsuit to basically halt the arbitration despite the arbitration agreement because he felt that the arbitration panel did not reflect his experience as an African American man. In 2018, Professor Homer LaRue of Howard University and I gave a presentation. And in preparation for that presentation, we did some statistical analysis, which I admittedly was a little difficult simply because the agencies did not keep statistics on arbitrators of color. And it was very difficult because many of the organizations did not keep such information as well. So what we discovered in working with our own roster with the National Academy of Arbitrators, and not much to anyone's surprise, that over the history of the NAA, going back to 1947, less than 3% of its membership had been people of color. And even though there have been an increasing number of women in the Academy, even today they represent less than 20% of the membership. Moreover, we discovered that even though there has been a number of programs focusing on recruiting more diverse neutrals, and the number of diverse neutrals trying to enter the field are slowly increasing, a significant number of these otherwise qualified neutrals are not being selected. So tonight we have an excellent and distinguished panel to discuss the need for diverse neutrals, the challenges faced, and the opportunities for recruitment, and finally, hopefully, some action steps that we can all take as members of the labor and employment community to increase the diversity of active selected neutrals in the profession. I would like to take this opportunity to introduce the distinguished panel we have with us today. First, we have Gwynne Wilcox. Gwynne is a partner in the firm of Levy, Ratner, PC, a New York law firm specializing in union side labor law, employee benefits, bankruptcy, campaign finance, election law, civil rights, and plaintiff's employment law. Gwynne's practice is devoted to representing unions before the NLRB and other administrative agencies and in arbitrations and contract negotiations. She is also the Associate Counsel of 1199 SCIU. She is a fellow and former board member of the College of Labor and Employment Lawyers and serves as the labor representative to the New York City Office of Collective Bargaining. Gwynne is a recipient of a number of awards for her representation of labor and contributions to the community as a whole. She serves on a number of community committees and task forces, and she has authored and published numerous papers in the areas of labor law and technology issues in the workplace. And like Ken, she is a recipient, and I know she has received the Lifetime Award from the Peggy Browning Fund, and she is a member of the board of the fund. Our next panelist is Haydee Rosario. Haydee is a full-time arbitrator with over 20 years in labor management relations. Haydee is a native of Puerto Rico and is a bilingual arbitrator and mediator. And she has experience in the private and public sectors with over a wide-ranging number of issues. She has extensive experience working with a diverse workforce in the United States, Puerto Rico, and in the US Virgin Islands. She is a member of the National Academy of Arbitrators and is on numerous panels, including the AAA, FMCS, and the New York City Office of Collective Bargaining. Haydee is a former member of the NLRB Region 29, and I should mention that all we NLRB former employees and alumni all stick together, and as a result, Gwynne is a former member of NLRB Region 2. And if I may brag, I am an alum of the Philadelphia Region, Region 4 of the NLRB. She is Haydee has formerly worked for the New York City Department of Education Office of Labor Relations. Lastly, I would like to introduce you to Alashia Chan. Alashia is someone I just recently met, and it's been a joy to work with. Alashia is the principal officer and executive secretary for the New Jersey State Board of Mediation. She is responsible for administering mediation, arbitration, negotiations, contract ratification, and union elections from her office. And she also provides analysis and guidance to the board's constituents. She is one of the New Jersey State Board of Mediation public board members and once served on the board's panel of arbitrators where she handled contract and disciplinary disputes as well as interest arbitrations. She's an experienced attorney with the New York State Bar with a wide range of experience in a number of areas of practice in addition to labor and employment. Her experience includes work in mass tort, products liability, intellectual property, franchise, and insurance recovery matters. She is also was a certified mediator for the Essex County Small Claims Court. This is a special privilege to work with this panel because not only does this represent the community with respect to color, but has what we call and what the word is used as intersectionality, because they represent a number of other unrepresented areas in our profession, including gender and language. This is intended to be an open discussion. I'm going to raise several questions to our panelists, and we'll discuss a number of issues concerning diversity and dispute resolution. While my panelists are answering the questions, I encourage you to put your questions in the chat. I will be monitoring the chat and interspersing questions as we go forward. Now, before we begin, we want to conduct a number of polls just to kind of find out a little bit about you. So I'm going to ask if I think Bernadette is going to put up our poll for us today. All right, there it is in front of you. You have three questions. One is to describe your constituency. The second question is a basic question. Do you select arbitrators as part of your work? And find, if applicable, from where do you select your arbitrators? From the agency maintained panel like the AAA? Do you have a permanent panel, which is a rotating panel? Or do you usually use direct selections? So take a moment to submit, and I think Bernadette will start the countdown. So just click a button, and when you finish, you can hit submit. Now, I note that some of you are, and I just tried to do it myself, that some of you, especially you are arbitrators. What I would do would be hit no. Do you select arbitrators? No, you don't select yourself. And finally, for arbitrators who are selecting this, what I would recommend is just tell us what's the largest part of your practice. Agency maintained, permanent, or do you get direct selection? All right, so we got 18, 21, 27. All right, there are 10 more people making up their mind out there. Slowly, we're coming up.
Do you get a message if you have submitted and it's accepted? Because my button is grayed out.
All right, that is because you probably, you have to hit, you got to answer all the questions for the submit button to open up.
So if you don't answer, if you say no to question 2 and you can't do 3, then your answer isn't submitted, is what you're saying.
Right.
Okay.
All right. So, okay, we got 31 to 34. I think we'll stop there. So let's see our results. All right, most of us are neutral. So we don't select arbitrators and applicable. Most of the arbitrators receive their assignments from agency maintained panels. So that tells us something that I think we can move forward on. All right, thank you very much. So I'm going to start with the questions if I can. It's just a note that Jim Kinney gave to me in the chat, and that Alashia is the first woman executive secretary of the New Jersey board in its 80-year history. Congratulations, Alashia.
Thank you. And thank you, Jim. Jim's always looking out for me.
I'm going to start basically, and this is a question for Gwynne as the sole advocate on our panel. And she's going to start our discussion on why is it important to diversify our panels. And so we're going to be talking from the arbitrator, the advocate, and the agency's perspective. Gwynne?
Thank you, Alan. And I wanted to say thank you so much to Ken Egger for having asked me to participate in this important panel. And it's been a pleasure preparing with this illustrious panel. And so I look forward to our discussions this evening. So I feel like, I know that many of you are here and you probably understand why diversity is important. But I think I'd just like to highlight a few things. And, it's part of our the law that we're not to discriminate against people based upon protected classifications. And so here we have a system where the appearance of lack of fairness and inclusiveness is not present in this area with arbitrators. And Alan, I'm glad you mentioned the Jay-Z story, because I remember when that happened, and it got so much publicity, but we've been talking about diversity far longer than when he had the issue with regard to commercial arbitrators. So, here we are in 2021, still, discussing this issue, but I think that it's important that we continue to have these discussions until we see that there, really are changes. So we want to make certain that the arbitrators, reflect the world and society that we live in, that there's, that there are arbitrators that reflect the race of people in our country and age, gender, sexual orientation, and so forth. But we also have to think about the fact that, diversity allows us to be able to see things through different lenses. And we think about, the protected classifications are really important, but also we have to think about what have people's experiences have been. Have arbitrators had experiences when, they were growing up, or, did they have the opportunities for education? And what were their educational backgrounds? And how does that relate to the grievance and the parties that come before you? Additionally, when we think about issues of age, we are oftentimes looking. When I remember when I first started practicing many years ago, so many of the arbitrators were very senior, and many of the grievance were not. And so you look at experiences like, how well did they relate to the grievance who were dealing with, very different generational issues than those of the arbitrators. And, how did people grow up in terms of, did they grow up in, in poor families? Did their parents have to work many jobs, or did they not even have parents, and, were they able to graduate from high school? Did they have to work while they were in high school and college and so forth? And so, many times, the experiences that you look at where it was mainly whites, many males, the experiences may be very different. And when Alan talks about intersectionality, it's both race and gender, and women's experiences may be very different. So we want to be able to have a system that is fair and has the appearance of fairness. So I represent a union that has most of the members, many of the members are women, many are Black and brown women, and they come from various countries and have various backgrounds. Some are, first generation immigrants, many have been here for longer periods of time. And their experiences are going to be very different than someone else who may have come from a more privileged background. So I think that, and then we all know about implicit bias. We all have implicit bias, but what are the, it doesn't. We have to be aware of them and be certain that we're not addressing them in ways in which they have a negative or adverse impact on decisions or decisions, whether you're an arbitrator or whether we're an advocate or just another person who's, interacting with a colleague. So, it's important that arbitrators are aware of that. And, I think that, many of the state bar laws now require more training for lawyers, but not every arbitrator is necessarily a lawyer. But we have to think about how are we creating a system of fairness. And I think about a couple of situations where I show the difference between someone who comes from a more privileged background and not understanding another colleague, a grievance issues, about where, someone got disciplined because they couldn't stay at work to work a double shift because they had to go pick up their child. And the arbitrator just didn't understand it. The person had never been asked to work overtime in for years, even though the employer had the right to do it. And that day they said, you have to work overtime, do a double shift. And they had to make a decision whether to leave their child in the child care center, where they would have been charged possibly with not, being fined for not picking up the child. They didn't have anyone else to pick up the child. And that child may have been sent to the police. And then goes another, this, God knows what would have happened then. But the arbitrator did not have that appreciation for understanding what was that this woman was faced with, this mother was faced with. And so that's just, to me, that was just always a poignant story about not understanding someone who's comes from a working class family versus someone, I'm sure this arbitrator probably had childcare for their children, where they would have someone, a nanny, to go pick up their child. And so they just couldn't relate. So I just, I think we all just have to be aware of these issues and how we don't judge people. We need to be able to make certain that we have a more diverse panel of arbitrators so that there is a system of fairness and an appearance of fairness. And, Black Lives Matters last year really, which, for many people was kind of new maybe, but it's, many people have been living under these circumstances, and the perspective that Black people often are not viewed in the same way, in a positive way, and it's, by others, is problematic, and it does translate into any type of system, not just arbitrators. I'm not just picking on arbitrators, but in any system. So, I think the need is there. And I think really that what this panel is about is for us to think about how we can make changes moving forward. So thank you.
Thank you. So Haydee, one of the important things you bring to the table, so to speak, is that you're bilingual and you're in New York. And so tell us the importance of just of that, as far as having an arbitrator that speaks the same language in many cases as the grievance.
Well, it goes to the point that, and first of all, thank you for the invitation and for the opportunity to share my experience as an arbitrator, as a Latina, and as a member of the LGBT community also, and working with a multilingual community and a bilingual arbitrator. And so just to follow up with what Gwynne is explaining, your ability to relate to the story, but also as arbitrators, I think we need to keep in mind that one of the most important things that we do is reach issues of credibility. Who's telling the truth, what makes sense, what doesn't make sense. And that is pretty much also permeated not only by your life experiences, how you are processing that testimony. And that's the first challenge. For example, not everyone, I know that in the legal field, I'm gonna get to the issue of language, Alan, but it needs to be within a framework of, it's not only language, is that we're dealing with a population that come from all kind of background and present their story and the testimony regardless of the preparation in a way that may be different than the way that we are used to processing it. And when it comes to language, it's a skill to have control of the hearing when you are hearing the testimony through the eyes and ears of an interpreter. It's a particular skill that you need to have, how you preserve the record. You know that if the witness has been talking for a minute or two and it's been crying or upset and visibly upset, and the interpreter only translates 2 words, she was told she's fired, you know you missed something in the story. And I think it's your responsibility to go back and say, excuse me, the witness spent X amount of time speaking. I would like to know, you need to probe. And it's not only Spanish and English. I mean, my experience with the labor board in 14 years in New York, you get Polish, Creole, Mandarin, all sort of languages, and that's as important as the intersectionality that you were referring to. Not every testimony is translated literally. And what do you do when you know, and I'm Spanish speaking, I'm fluent in Spanish, and so what do you do when you know that the interpreter did not translate properly, and how you preserve the record? And I have had many instances, for example, in one hearing in the labor board where we were trying to establish animus. And so the witness said that, he said that estaba caliente, but it was an expression. And the interpreter was like, he said that you were hot. It's completely different. So what do you do at that point? They have, it's important for you as an arbitrator to put on the record if you're bilingual, to preserve exactly and what the witness said, and also not to interpret for the witness, just ask the witness what the witness meant. But all these are factored. I don't think it's only about the language, Alan. For example, if you take how people, the sense of time, how we view time is very different in the Western culture and even in the legal field. We present a story that is very linear, that is past, present, and future, no? And dates are important and months are important. Not every, time is not central to everyone's story. And even when you prep a witness, that witness may not be relating to months and years the way you're relating to. And so the tendency is to, well, if he doesn't recall, it may not be a credible witness. Or if she can relate to date, time, you may have issues of missing the details, when in fact, time is not central in every culture to that story. And being open to understanding of those differences when you're digesting, telling what story makes sense in relation to the totality of the record, there has, diversity, the lens that you're using is crucial. And it's the same thing when you deal with authority. People's perceptions are different, leadership. I mean, that could be a whole training, but at the end of the day, it's a very basic proposition that your life experience matters. And it's not only about race or gender, but it's like the same thing, it's about class. You can have a very diverse panel in terms of race or ethnicity, that it's a panel that they're all coming from the same class. And they have no idea what it means to be in the situation that you described. Whether or not that may turn to be relevant or material in a determination of credibility depends on the case. And it's done on a case-by-case basis, but it definitely permeates the way that we all process information. I think that's sort of my 2 cents in terms of the importance of diversity in the decision-making process, the importance of understanding that regardless of the official language, we do live in a multilingual society, not only when you're in New York, but that those are the changes that we are all confronting on a day-to-day. And to the extent that we do not prepare to deal with their reality, then we are not serving our clients properly.
Okay. So Alashia, I'm going to hear from you on this particular issue. I know you have some broad experience, not only just with labor and employment, but with other areas in the court system. So I'm going to get your take on this too. Why is this important?
Or certainly, I again, thank you. I'm thanking the panel and also LERA for inviting me to this, to speak here. And, just from listening to the other panelists, I feel like, this is a great discussion, but I do want to keep this initiative moving forward. So I'm glad that I met and connected with you. As I'm listening to it as someone who is essentially running an agency, I'm not sure necessarily how there's so many facets of everybody's experience, how to to help make a panel that includes all that. I think as I'm listening to you, I'm thinking maybe probably at least in terms of what I can do is networking, so people can hear different people's stories, because people really don't fit into single categories. There's the intersectionality that Alan had mentioned earlier. But, so my responsibility in my role is to my constituents and also to the arbitrators that sit on their panel. So following up on the Jay-Z story, I do think we need to make sure the panels give options to the people who are selecting them. And right now we don't, and Alan, you had mentioned this earlier, in terms of having data collected on individual arbitrators, we really don't have that type of data. I mean, people can look at a name and say, well, that's probably a woman. Maybe they can kind of guess an ethnicity. I don't think we even have like a checkbox for language skills, but that would be something very useful to have. I think the arbitrators themselves, people use social media. And if you, when parties get a panel of arbitrators to pick from, they would probably go beyond the bios that we have, unless they already decided who they are familiar with and they want to select. My other responsibility is to the arbitrators, though, and I want to ensure that we have qualified arbitrators who are diverse. And I want to make sure that they are aware of the program at the New Jersey State Board of Mediation. A lot of arbitrators start their careers, I think, with our panel. But I don't know how many are aware of the panel. I think probably a lot of it is through word of mouth, and maybe that does sort of keep it to a more contained network. So one of the initiatives I would like to look at is, more of an outreach. I also want to make sure that the panelists, the arbitrators feel like that there is some sort of sense of belonging and a network where you can kind of exchange these ideas, where you can have these discussions, get to know other arbitrators, get to know the constituents. And then just rounding back to the constituents for a moment, I want to make sure that the parties that are coming to the table do feel like that their voices are heard and understood and valued. So that's basically my position from an agency head, a small agency head.
Well, I noticed that we have one question already. And the question is, and I guess it was initially directed at Gwynne, are you concerned that a union would select a minority arbitrator in a disciplinary matter involving a grievance of the same group? Is there an implicit bias in the presumption that a union would be better off with that arbitrator based merely on their identity? Unmute yourself, Gwynne.
So Jonathan, thank you for the question. I think that when we start talking about these issues, we are, I think one thing I want to underscore, we are looking for qualified arbitrators, regardless of their race, gender, sexual orientation, etc. But what we have been left with is that we're picking the same arbitrators, and they don't look like all the people who are on this panel. And so there's a lack of diversity it's a lack of diversity, on the panels from which we're selecting. So I think so we would not be picking as a union advocate, I would not be selecting an arbitrator solely because of the race of the arbitrator, but based upon what I believe would be the qualifications. But if we don't have arbitrators of color or ethnicity, age, sex, gender, and so forth, then you're picking from the same group all the time. And so, and as a practical matter, a lot of times I don't necessarily know the race of the person that I would be selecting, selecting an arbitrator for necessarily. And I probably would know whether the person was a woman or a male, but I would not know anything else other than that, really. So I don't think that, there we would necessarily say we would, we would be better off with the person based upon their base, but it'd be based upon knowing who the person is. And that's why it's really important that we have discussions like, how do we connect arbitrators of diverse arbitrators to the constituency so that they have an opportunity to be selected.
Well, one of the things that, and this is an opportunity to kind of expand this discussion to the next question, and that is the challenges of implicit biases in neutral selection. Now, I wanted to, my reaction to the question is that I have heard from advocates who would say they would never select a minority arbitrator in cases involving a grievant of the same race, simply because they feel that the person would be more sympathetic. So that is just another kind of example of how that implicit bias works both ways. Now, we can talk, while we're on that subject, we can talk about those kind of challenges with respect to neutral selection. I noticed that I said in the introduction that, we're slowly getting more and more arbitrators of, and I change my groups around a lot. So let's call it underrepresented groups. But while there may be more getting in the panel and we're recruiting and we're training, they still have to be selected, and that presents some challenges. So I'm going to start this part of the conversation off with Haydee. What do you see as some of those challenges?
So the main challenge is becoming selectable, which really it doesn't go hand in hand with either your experience. You could have a lifetime experience in the field and know a lot of people, and that doesn't necessarily translate in selectability. And the amount of time that it takes to become selectable. And in this, I must say that when I established my practice in 2007, most of the advice that I received was right on point from different sources, from different mentors. I thought, well, 14 years in the board, I'll be fine. Most people know me, most people like you. And, and at the time, most of my mentors warned me, it's going to take about 2-3 years to really, establish a solid practice, hang in there. And so the question is always how you hang in there, especially in the labor field where you have to practice and be, full-time neutral. It becomes a challenge financially of how you survive those initial years. That's one. That's like practical. How you support yourself during the initial 2-3 years, which is completely unrelated to whether or not you're competent or people know you. It's just an organic process because the decision that we make is final and binding. And at the end of the day, people need to have a level of comfort of how you decide and your cases, how you spell it out, how you run every hearing. And especially in the collective bargaining field, I think that the importance is not only how you decide, how you write it, is how you facilitate the process. And people need to have that level of comfort. And I'm gonna just also go back, and there's of course exposure. I think Gwynne and some of the other panelists mentioned the need that there needs to be a place where you need to interact. You have the opportunity to interact with the advocates and for people to know you. And that's usually one of the main challenges. Unless you're a professor and you're writing, it's really getting the opportunity to be out there. I think I do want to go back to this issue of not only of selectability, but how race or gender or sexual preference of other issues may permeate how people select you for certain cases. And this is sort of, it may be based solely on my experience, but my take is that if you're consistent in your decision, if there's certain consistency in your decision, if you develop and how you treat people, your reputation precedes you eventually. If people really understand and trust that you're going to be fair, no matter what the issues are, you get selected. I've been surprised when I've been selected by people that I don't necessarily know to deal with racially charged cases, whether it's someone terminated because they were posting KKK materials, or issues involving police and social media posting and First Amendment. When you're selected, you said, okay, so I guess they have a level of comfort. You're selected by both parties that you can be fair. So it is doable. The way that I don't think it's only about exposure. I don't think it's only about reading your experience in the resume. I can't stress enough the importance of having your own center, consistent. It'll give you longevity. You can't, there are times you're going to have to fall on your own sword if you want to have longevity. And I think that's essential if you want to be selected eventually to a broad range of cases, regardless of your cultural background or ethnicity. Is the basic thing. Do people trust your decision? Do they trust that you're going to be fair? That's sort of my take on that.
Well, I know that, Alashia, you get a lot of new arbitrators that are starting their careers who may come into your agency. Do you hear any of their frustrations about selection from where you are at times?
Well, I've actually only served as executive secretary for about a month now. So I've sat as a public member for the board for a while, but actually what I've seen more recently is people that want to be on the panel that are retiring from, a very prominent in their industries and probably widely recognized already. Now we have had some new arbitrators come in, and we have to some extent we're maybe more flexible than some other panels in terms of who can get on the panel. We do have a certain level of criteria so that anybody that is on our panel is qualified. But for the newer arbitrators, I haven't heard anything personally or through earlier executive secretaries that there was a complaint about or a concern about implicit bias based on race or gender or some other status. Basically what I hear is it's just and to echo what Haydee said, it's a long waiting game to get into the industry. And, I've spoken to some people, and I think that to some extent, people's socioeconomic status maybe makes it harder to wait out that waiting game. So for example, if someone has a little more financial security or an alternate stream of revenue, maybe they can put in that 2, 3, 4, however many years it takes to kind of get there. I mean, what I personally did was, because I'm a lawyer, I had worked as a contract attorney, and I did it more in litigation, stayed out of the labor field. But, that sort of drew me into a different career path because that's, I had to support a family. That's where I ended up going. So then I left the arbitration field. I did stay connected with the labor community in terms of serving as a board member on the board of mediation. But, that was my path, and I don't think it's necessarily going to be somebody else's path. But it is hard. It is hard it's just one of those industries where it's hard to make a go at it. If this is your financial stream and you're relying on this to support your family or support yourself.
From the grievance point of view, and I'm going to kind of preface this by bringing in Betty Widgeon's point that, you know, she was the first person of color in her county, and Betty is from Michigan. And she said that she got a sense of relief from many of those coming before the court. Not that they thought they were going to get a break or a win, but because there was a sense that they probably would not have to, quote, wade through so many layers just to recognize that they were people first, just like me. No matter what reasons brought them to court. Now, in arbitration, I know you face grievances who, you know, I guess the issue sometimes is whether they have a sense of getting a fair break in the arbitration proceeding, and in the decision making. What's been your experience with that?
I would say it's varied. I would say that grievance are often, you know, many times that this is their one time or their only time doing, you know, being an arbitration, so everything's new. And of course, in this day and age, when everyone thinks that they know more about the law because of all the TV shows, you have to, like, you know, manage expectations, and the arbitration or even in a court proceeding. But you know, I think there's a sense that it's really a foreign experience, and you know, but if there is a woman at the head of the table, many times that's you know, and you have a female grievant, I think that they feel more comfortable. And the same way that if it was a person of color, that they would feel comfortable as well. You know, no one goes in knowing whether you're going to win your case beforehand, you know, of course. But I think there's a, you know, there's a comfort level, and it's, you know, and I think it's also given people's experiences. Like if they see someone at the head of the table and the only people that they deal with that look like that arbitrator is their supervisor or the head of the company, and that they don't really have a, you know, they haven't had a good relationship with, or, you know, it's not an equal peer-to-peer relationship, they're going to look at that arbitrator in a different way. So, you know, and it will vary from person to person, because obviously we all have different experiences, you know, regardless, as Haydee says, you know, based upon who we are as individuals. And so, but I think there is the credit, I think it does lend credibility to the process when you do see someone who is that, you know, there's a thought that this person may look more like you or have some similar experiences.
One question that I think all three of you, I know especially Alashia and Haydee raised, is when getting started, it's the question of income. You know, how do you maintain an income to support yourself and your family? Now, I know that there has been some controversy relatively recently in the labor community about that question of neutrality and individuals, you know, having to basically give up their practice in order to become an arbitrator. Meanwhile, there's some others who feel that, you know, that the quote unquote, the neutrality that is unique in labor arbitration is essential to the credibility of the system. Anybody care to comment on that? I know that there's a lot of very strong feelings one way or the other on that. So do any of you all have any real comment on that? Should we allow arbitrators who are starting out to be able to continue to work in their field while they're trying to build their practice?
I would say that I think it's something that should be looked at, just because I do think that you know, I think it's an impediment for many people if they you know, have to give up their day job, so to speak. I think I would say that there's probably ways in which it could be done that would not cause, you know, total dissension and breakdown of the process. So that if someone was working in, in an area where they were just doing private sector work, maybe they could decide cases in the public sector. I think they still, would have to go through their normal recusal process to make certain that there weren't any overlaps and so forth. But I do think there might be ways in which to do it, but it would, I think it would take some discussion. But I've also been on the other side of it when I've had an arbitrator who was an adversary starting his practice, and AAA put his name on a list, and then AAA ended up, appointing him. And it was like, well, we battle every other day on cases, so that's not practical, but I do think that there are ways. But
anybody else?
I suppose there might be ways to get around it. Like I just working in law firms, sometimes you can get around conflicts by putting up some walls, but it's always one of those areas where even if there's that appearance of impropriety, you kind of stay away from it. And for our panel arbitrators, we do have the expectation that they be neutral. We haven't ever gotten to the point where somebody has pushed back and said, like, but I can do this, that, and the other thing. And then you have to get to the point where the parties actually are going to select you, and you would need to make that disclosure. And you wouldn't want to get so far down the line into the process where then all of a sudden someone's going to challenge your authority because they don't think you're going the right way. So, it's a very tricky area. I think even arbitrators who are coming to our panel that come from either a labor side or the management side have some difficulty getting past, like, this was my experience and I, fought for labor for however many years, but once they retire from that, they're open to as long as they meet the certain criteria for our panel, they can be on our panel. But then it's up to the parties to decide whether or not they think that they can bridge that, gap from where they used to be on one side or the other side.
Yeah, Haydee, you were going to say something?
Yeah, I do understand that it's a challenge because I think the labor bar tends to be small. Even if you're practicing outside the tri-state area, you tend to run into the same people. So that presents a challenge of how you can accomplish that and still prevent either the appearance of impropriety or any conflict. But I think there are other factors that are bigger impediments to establishing a practice within a reasonable time, which is there has to be a commitment from the top, whether it's from labor and management or in the private sector, to diversify the pool of arbitrators. And because we all know that the tendency is to select the same people. And I believe that if you have other means of trying new arbitrators, and I know that there were some unions in New York that had at some point expedited panels with certain type of cases that were appropriate for new arbitrators. And it gives you a means of not only of trying new arbitrator, but also, keeping you working in the meantime. So you have expedited panel, there are ad hocs, there are other means of opening the doors to new arbitrators, so to ensure that process takes place and that it's doable, really. Because you can have, even if you don't have that criteria where you have to be neutral, what's the point even if you survive? Like I said to some of my mentor initially, well, I come from the base. I'm used to being broke. I'm broke with money and without money, and I want to do this, and I'll hold on. And I know there were some arbitrators who started with me that we used to be very supportive of each other throughout the process. But there has to be some structural change, some change that goes beyond money, or how you live
Mm.
through, or whether you're neutral or not. It's about how you provide the opportunity, how you start selecting people that are not the same people that you selected for 20 years or 30. I mean, I know of specific cases where the arbitrator are still being selected even after they die. AAA is still sending their name. So, it's like at some point it becomes ridiculous. So we need to have that conversation, but it's not going to happen unless there's a true commitment to make it happen. I think there is a disconnect, for lack of a better word, to if you're dealing with the labor side where you are going through negotiations and the table in the negotiation look quite diverse. And the membership is there. And the membership tells you the needs and, this is our list of demands. And there's a whole process that is quite diverse. And somehow, when we move to the decision-making process, we disappeared. For whatever reason, because the attorneys are choosing, selecting the arbitrators. There has to be some kind of commitment to make that process work. The same way that you bring people of color to the table and you think that it's important to bring women and you think that it's important for LGBT to be represented in certain issues and, you're supporting Black Lives Matters and you're marching, you need to review the process. And the process cannot be limited to saying, well, you need to be full-time neutral and too bad that you can live 2 years, until you become selectable. It has to be a commitment. Otherwise, we're going to continue to have the same conversation day in and day out. You're in, you're out. It's 2021. We're still discussing whether diversity matters. When we all know that it does, that our decision is final, is binding. And when you reach issues of credibility, if the witness is invisible, which is another sense, people, it's like that matters. You walk into the room and you know that the arbitrator sees you, meaning, symbolically see you. You're not just the clerk, who was fired and has this story to tell and I have to review the contract and I have to review the document. No, you see that person. You see the humanity in that person. You see the story within the story. We get paid the money we get paid to make judgment calls. And the story really happens in the gray areas, not in the black and white, not in the explicit terms of the contract, but many times when you're dealing with disciplinary matters, it is in the gray areas that the story happens. And if you don't see the witness because you don't see the humanity in the witness, you can't tell me that it doesn't matter. So there has to be a commitment other than marching and holding park card to move people of color to the decision-making place.
All right.
Oops,
Go ahead,
sorry.
Gwen.
Yeah. Oh, wait. Alashia, you want to say something?
Oh, you can go.
Listening to Haydee makes me realize that
of the directorate.
there needs to really be a joint effort. And when how many contracts have I negotiated over the years, and we have some contracts have panel arbitrators, some have require AAA or some other arbitral forum, but at the time that you're negotiating is probably not the time when people are actually, we're like, we're trying to solve so many issues, and that's not necessarily the time to put, that's not necessarily a priority on the, during collective bargaining. But I do think that, my clients would be, very happy to see more diverse arbitrators. My firm would be interested in seeing more diverse arbitrators. But I think that I was going to say it's like the responsibility of the parties But I also think it's, which is true in part, but I also think that it's the responsibility of all of us. And, all the arbitral agencies, because we got to do this, we're all, intertwined and interconnected. And so that, one of the natural things would be, well, let's call AAA and see who they have, and but then there has to be more than just like providing a list, because if the parties don't have an opportunity to meet, network, and figure out who, some people are, not that, I think it's always a misnomer that the diverse arbitrators don't have experience. They have many years of experience. It's just that they may be new to the arbitration field, but not new to labor and employment. So we have to figure out how there can be more of a collaboration to draw attention to the deficit in the lack of diverse arbitrators. And, during one of our prep sessions, I was saying that, we shouldn't be inventing the wheel. Alicia's in this new position. She's, interested in seeing what more can be done. But we've had, AAA has been long-standing, this FMCS and, agencies and there are other other forums. So how can we, really draw attention to the need? We know the need, but how do we make, how do we act upon this? And I think we have to figure out a way to do it in a collaborative way.
Alashia, you was going to say something?
Yeah, so just going back to some Haydee's comments and then circling back to Gwynne. So I do believe that most of, at least on our panel, the arbitrators do see the humanity of an individual grievant, but I do appreciate that there are so many other nuances that as individuals, a lot of us don't see, so there is definitely a value to having the diverse arbitrators and having diverse arbitrators being recognized and then also being selected. And just from some of my experience in big law, I know that a lot of the diversity initiatives were pretty much driven by the clients that were demanding that attorneys working on their cases, or at least teams, have a certain amount of diverse attorneys serving that client's interests. But I do agree that, it is a collaborative process. I don't think it's just saying, hey, it's got to be the parties that have to make the decision, but they ultimately do. But to the extent that I can help with outreach, make, help get arbitrators mentoring opportunities, networking, building their social capital through networking opportunities. And, and I've seen some of their faces on the little pictures for the Zoom call. We do have a number of diverse arbitrators on our panel who are very successful. I would agree that we don't have that many, but the ones that we do have, Haydee included, and everything's relative because, I don't know how often you necessarily get picked on our panel, but you do get picked more than most of our other arbitrators. So maybe it wasn't by design, but I think that at least it's working to some extent. I do realize there's a lot of work to still be done. So, I do have on my list of things, outreach to minority arbitration associations, the legal community, because I have ties there in terms of, to the extent the attorneys are picking people. And I think the diversity conversation initiative has been going on for probably maybe a longer time in the legal community. And even this year, there is a requirement for attorneys on their continuing legal education to have a component that is related to diversity and unconscious bias, to have that as part of what they have to put in hours learning about. I think it's maybe a couple hours out of 24 for the year, but it's still, steps that the Bar Association's taking. So the lawyers are aware, what they do with it, we'll see. But, I think, and then it's the constituents who are the labor and management leaders. And I know Haydee was talking about it, and I really don't know where the disconnect is in terms of there being a collection of diverse people at the bargaining table, but that not transferring over to, who people pick as their arbitrators. And, I just don't, I'd love to keep exploring it and talking about it, but I don't know where that disconnect is. I don't know if maybe somebody out there does.
Right. Well,
but it's definitely something to think about. Maybe people aren't aware that it's happening or they don't appreciate it.
well, we know that there are a number of programs that a number of organizations have done to recruit arbitrators. The AAA has the Higginbotham Fellowships. The New York Bar Association, who's headed by my good friend Tim Taylor, is trying to do a lot of initiatives in New York, and I know Alashia is recruiting in New Jersey. The Academy has its programs, including its recruitment and as well as its salons, in which is recruiting new arbitrators. I also want to take this opportunity to announce that the Cornell ILR School now is going to be offering a master's in dispute resolution. And I think that begins in September. And individuals who would like to seek that have to be on campus, I think, for a semester, and that scholarship money will be available. So, there are a lot of opportunities to get people into the system. I know Homer LaRue and I found, and from our empirical analysis, is that what is critical here is that there be, and we call it a certain mass of individuals of color, or to actually kind of force the choice, in other words. So, and we're recommending that that panels have at least 30% individuals, people of color, because they found that once you have basically 3 out of 10, 3 out of, that because of that there is more of a chance that the arbitrator selected will be the person of color. But there are other things that we can do. And so I would like for you all to talk about what other kind of things that we can do as individuals, as arbitrators, as advocates, in order to increase that type of diversity and the intersectionality in our ranks. I know Gwynne says this is the responsibility of everyone. Gwynne, I'm going to start with you. And is there a way we can expand on that?
Yeah, I mean, I'm just, kind of as we were talking, it just made me think that, when I think about the arbitrators who were new at some point during the course of my career and now are well established, I mean, they started somewhere and they actually, I think went through, being mentored by, excellent arbitrators. They also had to, they participated in LERA programs and AAA programs and Bar Association programs to maybe some of them were geared towards arbitrators, but not necessarily, but just an opportunity to really meet the parties. And so it just seems to me that but the networking piece to me is like the hardest part in terms, because as a party, I don't necessarily know a lot of new arbitrators, but if I'm going to conferences, I meet new arbitrators or aspiring arbitrators. So it just seems to me that there needs to be some small room sessions where you get to meet people. I mean, one of the things I remember when I first started practicing, and I didn't know any arbitrators, I remember AAA used to have their holiday party, And that was a way that you got to meet people. I don't know now if we'll ever have a party, in-person party anytime soon, but though, and so, are there opportunities to replicate that in a way so that the parties get to know people? Maybe, Zoom allows for those opportunities to have smaller sessions that maybe are facilitated by more seasoned arbitrators who have, are mentoring, or who are mentoring newer arbitrators, and, have groups of, advocates meet with people, because I think those are I think that's how it's a matter of, when you have to make it, when you're selecting an arbitrator and making a recommendation to your client, or be able to explain why are you using a new person, so, if they ask, they don't necessarily always ask. You want to be able to say that, I've read this person's decisions, some of their draft decisions, they've been mentored by, Alan Symonette and or Haydee Rosario, and so we, we're going to try this person out on a case. So I don't know, I feel like maybe smaller settings that we have a chance to talk.
Yeah, and I'm going to invite, I know there are a number of newer arbitrators on the call, and I'm going to invite you to kind of put your comments in the chat about what your experience has been. So please, I'm going to invite you to do that. Any opportunities as far as Alashia, from your point of view with the agency, of specifically kind of encouraging more arbitrators on your panel?
Well, it's definitely a network-based culture. So at least in terms of my intentions and outreach, would be, Dean Burrell was sent me a chat earlier, in terms of reaching out to other associations, minority arbitration associations, just to kind of see who can I network with and connect with other people. Gwynne had mentioned just what other associations are doing. So, I've started to look at that, see what's working, what's not working, why it's not working. We are a much smaller agency. We're housed within the Department of Labor, limited resources, but it is a good, like I said before, I think a lot of new arbitrators do come to the Board of Mediation as a launching point. We do have a cap that we allow our arbitrators to charge, because we are mission-based, not a profit-based agency. So the mission is to promote harmony between labor and management in New Jersey. So we do try to contain costs while providing, competent and excellent arbitrators on our panel. I know I've seen their pictures in the panels here. I know the Department of Labor, it hasn't happened yet, but they're welcoming a diversity officer. So I definitely intend to speak to that person when they come on and see what isn't within my parameters to do, what's consistent with state policy, make sure I'm not stepping on my toes. I know the board who I report to is supportive of diversity initiatives. It's just a matter of, what we can do with our resources, and, what we can learn from others, and what's worked, what doesn't work. And then just maybe get more of the buzz out about the New Jersey State Board of Mediation, because I'm not sure, I'm really not sure how we have a website, but I'm not sure how it is that people decide that they want to come to our panel to begin with. And I don't know if it's word of mouth, but definitely to the extent that we can expand that outreach to more diverse candidates, that would be great. And we do have a mentoring program. So it's kind of been stalled because of the pandemic, but part of that is finding people and helping people connect with other people who are breaking into the industry. And it's not all, it's not all people fresh out on their careers, because I think just in terms of being an arbitrator, you do have to have a certain level of experience, relatable experience, before you even get to that point. So, and we certainly have some younger arbitrators, but I think a lot of the people are more seasoned somewhere in their career, and that's how they've how they start on the arbitration panels.
All right. Haydee?
I mean, I think now that more arbitrators are conducting hearings via video conference, whether it's Zoom or WebEx, or it's going to allow arbitrators a greater opportunity to mentor, to make it easier. I know one of the challenges when I was mentoring some of the new arbitrator was, having a lot of the hearing outside New York or upstate, or the hearing being, canceled, or the location of the hearing being an issue. But now that it's via Zoom, I think it's easier to have people shadow you and see how a hearing is conducted, and also to help them with the writing process and to see a hearing from beginning to end. And I think we do have a responsibility also. That the same way that people helped me and took me under the wing and sort of, introduced me to other people, it's the responsibility of arbitrators who've been lucky to establish the practice as me to also mentor and make themselves available.
Definitely.
And I think that.
Oh, sorry. And I was thinking that is also an opportunity for perhaps newer arbitrators to connect with maybe arbitrators that are more seasoned, that aren't as comfortable with a technical process, because now you're adding value to, as a mentee, to that mentorship program. So that might be, I mean, I think a lot of people have, but I think there's still arbitrators that are putting cases off to the extent they can, till people can meet in person. But that is another opportunity. Usually, someone maybe that's a little more tech savvy, that's looking to break into the industry. If you're trying to connect with someone, maybe you can help them in that regard too.
That's a good point. And so I think we have a little bit less than 15 minutes. I'm going to kind of solicit any final questions, either in the chat. Do we have any further questions? Going once?
I think there are some in there, Alan, if you take a look.
All right, let me go up.
Oh, wait, what is this?
Okay. All right, there's one point I'm going back up that I know Dean had mentioned, that the AAA will send out all diverse panels upon request. And I see Ken just put something in. It's a long statement. I'll do my best, Ken, but it says AA's mission and vision statement asserts a shared commitment to a diverse roster of arbitrators and mediators. The AAA roster is comprised of 27% women and minorities, and this figure is increasing. AAA division executives around the U.S. actively recruit women and minority candidates who meet the criteria established to the panels. And one of the things that I do boast every time we talk about the AAA's programs is the Higginbotham Fellowship. The AAA has the ability in its algorithms to provide arbitrator lists to parties that comprise at least 30% diverse panelists where parties' qualifications are met. And then we talk about the Higginbotham Fellows Program is a highly visible and extremely successful program created in 2009. It provides training, network, and mentorship for up-and-coming diverse ADR practitioners. Fellows not only have advanced to appointment to the AAA roster, but have also been selected to serve on cases. One even has joined the AAA's board of directors. And I do kind of like to mention the Higginbotham program. I know I've mentored a few of the newer arbitrators who have come through that program. I know that we've had some people who, I know we had one question that I did not get to, and that was Patrick Westerkamp had some commercial comment about that. AAA commercial arbitration statistics show that in the rare instances of two arbitrator cases, there rarely is a dead heat. When protected status at the heart of the grievance Should agency rules permit appointment of 2 arbitrators, i.e. or e.g. a Spanish speaker and one fluent only in English? I know from the non-commercial side, I don't have that opportunity. I've only had to work on panels with other neutrals, but if anybody would like to weigh in, if they have any knowledge on that. All right. Okay. Any other questions, final questions before I turn it over to Joe?
I have
Jonathan.
I have something I'd like to say.
Okay.
I've been an arbitrator for about 25 years, and pretty much this same question comes up time and time again. I think we as arbitrators really don't have an opportunity to change. It's got to be someplace else. It's got to be maybe at the negotiating table, or the companies like AAA who send out arbitration lists have to change their method of doing that, giving everybody an opportunity to to get chosen. And the way it is now, we get arbitrators that get a lot of cases and some that get none. So, and it's in the list that goes out. That system should be changed somehow or another. And we as arbitrators have to talk to both sides of the table and talk to them about putting mediation as part of their contracts. That would give them an opportunity, or the mediators on the panel would give them an opportunity to get their feet wet in the labor movement.
Well, I know that the AAA, for example, offers that service for mediation, but I also know that Dean he is currently the chair of the National Bar Association ADR section. And they have a list of qualified mediators and arbitrators, and he put the link in the chat. So if you want to touch base with that, please take a look at the chat. Anything else? Jonathan, I would first of all would like to thank our panel. Thank you for providing your ideas and your thoughts on this very sensitive subject. I know that the discussion will continue. So I wish all of you well. And with that, I'm going to turn it over to Jonathan.
Thank you, Alan. You did a fantastic job. I think that everybody got something out of this and learned a lot about the challenges that are being faced by minority arbitrators and the challenges about really raising a new generation of people that could potentially join the field. So I want to thank the panel for doing an outstanding job. And I want to thank everybody who came out to our final meeting of the year. I do have a few announcements before we wrap up here. For one thing, the 73rd annual National LERA meeting is coming up. That's June 5th through 8th. This year it was supposed to be in Detroit, Michigan, but rather than go to Detroit, you can sit here and go on Zoom because it's going to be virtual this year, not surprisingly. And it should be a fantastic program as always, and a little bit easier to get to since it is virtual, unfortunately. One of the things that will happen on June the 7th is I'm going to be giving a program speech about sort of building your chapter. And one of the things that we're going to talk about, we're going to be honored for the New Jersey chapter. We've received the Star Chapter Award for 2021. I don't know if we're the only recipient that received that recognition, including merit awards for consistent chapter excellence, chapter communications, conducting a joint program, which we did with National LERA, outstanding programming, chapter, national relations, and community involvement. So I think that that's testament to our membership, to all the people who come to these meetings, and to our executive board with people like Ken, people like Pat, who just stay involved, put together great panels like this one. And that's really the lifeblood of our chapter. June Jim Kinney, did an amazing job as always with the elections. I have to give a shout out to him. Jim learned Zoom. I got to tell you this, like with I think COVID lockdown executive order was like March 16th or 17th. By like March 19th, Jim was a Zoom expert. He could have taught lessons. Unbelievable. The guy had backgrounds before anybody. I've never seen anything like it. The guy could do Zoom like nobody else. So I've got Alashia. It's the first time hearing from her. Obviously she's stepping in for our former board member Ernie Whalen, who was tremendous. Lost to the labor community, but it looks like he's going to be followed up with very capable hands. And Alashia, who works with Jim. So Jim has always done a great job for us, and we're really happy to have him on our board. And Lucille Alfano wanted me to let you all know that she's a Higginbottom Fellow. So it shows you what great people can be turned out by that program. And she's serving on as a vice president again. So very lucky to have her on board as well. So I just want to thank everybody. I'm just going to drop the chat here for the national meeting. Hopefully you folks will consider attending that, and also come back and meet with us again next year, probably another virtual year. And I'll leave you with one other thing. We try to have a neutral oriented event at least once per year. It tends to be our May event, although that's not necessarily the case. We're open to some ideas because we've tried doing speed dating. People didn't like the term dating, but the idea is short meetings between advocates and neutrals. For 3 or 4 minutes, you move, meet somebody else. That's one idea we've tried. This year we obviously had a topic discussion about an important topic. We've thought about having sort of a group of new neutrals who people may not have heard of, but have come on their list, kind of introduce themselves. So if anybody has ideas, email them to me, email them to the LERA group, email them to anybody who you know is a board member, and it's something that we could discuss at our July reorganization meeting, because we're always looking for new ideas on how to deal with that. And I need to thank Emily Smith and Bernadette Tierman for being such great hosts, sharing the Zoom platform with us, the University of Illinois, which is where National LERA is based out of, and just being such great partners. So thanks to everybody for a successful year, I think, as we could have imagined under these challenging circumstances. And thank you for the panel for this enlightening discussion tonight.
Thank you.
Thank you.
Thank you. It's my
Thank you very much.